I just pressed the Let's Go Live button. It is a lovely, lovely Friday. We got to wait for the tubes to connect themselves as we close out the week. It's an incredible morning, and we're here a little bit early today. And so let's make sure the tubes are working before we continue to ramble off here. Make sure everybody's joining us and having an amazing day. It looks like we are connected. That's tremendous news. And it's showtime, my friends. That means we can go ahead and get started. And so let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Donald Trump's petition. You might call it a lawsuit. You can say he's suing him or he's petitioning him, but it's Judge Engoron. And yesterday on the show, and I know this wasn't that long ago since this is an early show today, but we had a full breakdown of the staying of the gag order. Okay, so this guy, Judge Engoron, very unhappy that Trump and his defense team have been talking about his Greenfield. This woman right here, you can see him leering kind of over at her like, hey, what's up, baby? Hey, court clerk. And so, anyways, having a conversation in his mind that we don't want to be a part of. And he said we can't talk about her, but this went up to the Court of Appeals in New York, and the Court of Appeals lifted the gag order very temporarily, said, look, it's an interim stay, okay? Trump, you can go out there and you can start talking about the judge's GF, the judge's Greenfield. Her last name is Greenfield. And so Trump went wild, right? He said, okay, perfect. So he started dropping some stuff on True Social about 4:44, right after the stay was implemented and the gag was lifted. And so we'll see what he said about it. But what I really want to do, what I'm excited about, is this, which is the full petition. Okay, this is the full lawsuit. We did not have this yesterday because yesterday was all kind of breaking. It was like fresh. They just had the hearing. It was an emergency petition kind of a thing. And so we got the full petition. And look at this, my friends. Let me just show you this. Take a look at this number right here. 2,096 pages. Whoo! That's a big one, all right? And now the full petition that we'll read through is not. It's only about 50-something pages, so we'll see what's inside of it. But you'll notice that there's also all the transcripts, okay? So they've included all the transcripts and all the notes from all the proceedings. So basically what they've done here is they've chronicled all of Judge Engoron's, goofiness, his misconduct, and they've assembled it as part of this appeal. And this appeal, these are issues that might, ultimately be decided by the Supreme Court. So I want to spend some time going through it because we've got a similar issue with Judge Chutkan and her gag. And we've got this real big problem where you have these two, unstoppable forces and an immovable object kind of crashing into each other, the free speech rights versus the due process rights of a court and, the sanctity of the courtroom and all that kind of nonsense. So we're going to talk about that. Then we've got a clip from Alina, who is out. She was explaining what the mistrial motion looks like. And this clip was interesting because it was like right before the gag order was stayed. So we'll hear what she said in the morning, and then everything kind of changed a little bit that afternoon. But they're very commingled, right? The mistrial, in large part, is about the gag, and the gag was in response to conduct about the trial that was misconduct that would lead to a mistrial. So we've got a lot there, and we'll check in with Alina and see what she has to say about it because, of course, she's a brilliant legal scholar. And we also are then in our second segment. We're only going to do two segments today because we're going to spend a little bit more time on that first segment, and then we're going to jump in for our members-only after party here on the day and spend some time there. But our second segment is going to be about the 18 state attorneys general who all are filing an amicus brief. So as friends of the court, friends of the appeals court, we know that Judge Chutkan also issued a gag order against Trump, and this one wasn't as insane. I mean, they're both insane because everything that's happening with these cases is insane. But if we're putting, like, if the insane scale starts, Judge Engoron is much higher than Chutkan in terms of his insanity, because at least Chutkan wasn't talking about her, law clerk, BF or whatever on the bench. But anyways, so we'll talk about this because she's trying to impose the same thing. And we'll take a look at the docket because this is also at the Court of Appeals, right? So Trump won at the Court of Appeals, got the interim stay in New York, but a very similar issue is at the DC Circuit Court of Appeals. And yeah, I really think this is the biggest case of all, right? The January 6th case, it's not getting a lot of attention as much right now because the other cases are kind of in trial, and we got video from Fannie's case and other stuff. But this is a big one. And Trump is, I think they're really like, this is the one where they're going to put all their eggs in the basket here. They're really going to try to get a conviction out of this one. If they don't get a conviction out of Mar-a-Lago, okay. If they don't get one out of Fannie's case and the RICO case, okay. But they cannot lose this insurrection case. So all the eggs are in this basket, and we're at the Court of Appeals. And so what happens now is people can file petitions or amicus briefs saying that they're friends of the court, friends of the case, and that they have an opinion on this. And so we have this one that was filed by Missouri Attorney General. His name is Andrew Bailey. You remember him from other pretty important cases, like the Missouri versus Biden case, where the censorship of the Biden administration was put on display and then dealt with and summarily disbanded by the federal district court. Andrew Bailey and his team were the people behind that, and so was Louisiana. But they've gotten together with 18 states total. So 18 states are now going to be submitting an amicus brief to the DC. They have submitted an amicus brief to the Court of Appeals. And so when we go through this, you'll have to ask yourself if your state is on that list. And of course, if you don't have a Republican attorney general, you may not be on the list. But there are 18 people representing the states essentially and saying, look, gagging Trump is impacting our state citizens' rights. I mean, how can those citizens hear from a candidate that they want to hear from if he is gagged, right? It's not only Trump's free speech that is being violated, it's all of ours too, as listeners. And then, because it's Friday, we just want to end this week with some extra painful clips. We've got Adam Kinzinger, who's going to come out and say, Trump is the greatest threat ever. And then Christie's going to do the same thing. He's going to say, Trump's going to be under 4 indictments. I mean, he already is. And he's going to be convicted. And so you should elect me because I am not being prosecuted by the weaponized partisan hacks on the other side, right? I guess I'm more acceptable because I'm not an enemy of your enemy or something like that. Very strange. And then we'll close out the day with Marjorie Taylor Greene, who says, what's going to happen if you put him in prison? We'll vote for him anyways. And she's right about that. And so, as you can see, my friends, we got a couple good segments to get into today. It is a beautiful Friday, and we are here a little bit early today. I do have a 3-day event that I'm going to be jumping into here later on in the day, and it's all very cool stuff. We're going to hop in. We're going to take kind of an adult field trip. I'm a part of this group, and we're going to take this adult field trip out to an abandoned kind of ghost town that these guys in Arizona bought. They bought this town, and it's kind of this interesting project that they're working on. And we're going to go look at it and see, it's kind of removed from society a little bit. It's kind of out there, and they're working on some cool stuff. So we're going to go see what that looks like and learn some cool stuff over the next few days. And I'm sure that I'll be sharing some of that and integrating some of that here. But we do have some business to attend to here today. And so we're jumping into things a little bit early. And before we get into the meat and potatoes on the day, of course, it is that time of year, my friends, where we've got some pretty amazing deals out there floating around. You're probably getting all the emails, in your inbox, hey, this discount, this discount, that. But let me tell you about this one because, oh my goodness, it's finally here. We're friends with our friends at Field of Greens, of course, but check this out. Black Friday sale is on at fieldofgreens.com, and it's a smoking deal, right? We had to change the promo code. That's how good the deal is. It's incredible. Right now, 30% off. You just got to use the promo code VIP. VIP. So you're used to using an old one here. Use that one, and you're going to save even more, which is crazy because the other one was pretty good too. But we all love Field of Greens here. I love Field of Greens. I've been using it. I know many of you have been using it. We've talked about some of the results. Things like more energy throughout the day, right? It's vegetables, it's fruit. It makes your skin look a little healthier. Things like digestion, stomach feeling a little bit better, hair, nails, things just looking healthier in general. And you have a little overall pep in your step. You just kind of have that glow, that feeling that things are a little bit better. And so, I promise, I use this. I promise that this will be one of the best things that you add to your life for the better and for better health. It's fruits, it's vegetables, it's a daily routine to get into. It's very good to think about health on a regular cadence. And so don't miss this massive sale, my friends. Save up to 30% off your order. Just go to fieldofgreens.com, enter the code VIP. That's fieldofgreens.com, and the code is VIP. 30%, man, it's a good deal. And remember, the vegetables want to be eaten, okay? That's why they're here. That's why they come out of the ground, bursting with color, bursting with flavor. And that's why they want you to eat them and be healthy. And of course, the hair is not included with the production of the promo code VIP. But check it out, VIP.com. You'll love it. All right, now, Our website, if you want to get any of the PDFs that you see here today, we're going to post them on our website, robertgovea.com. We've also got the daily show reports are posted there, so you can watch all the segments translated into different summaries, and the videos are there, the PDFs are there. If you want to browse this exact mind map that you're looking at right now, there's also a tutorial there at robertgovea.com. Sign up for the daily newsletter, get all this stuff delivered to your inbox, and it will show you how to use this mind map so you can navigate at home. We also have our community Watching the Watchers.locals.com, where we're going to be heading over for our after party. And also for members, we do a members stream on Saturdays. Members, our morning stream will be a little bit early tomorrow because of the event. So 9 a.m. Eastern time is the planned start time for Membos tomorrow. Membos on Locals, Membos on YouTube. We'll be starting at 9 a.m. Eastern time, 7 a.m. Mountain time, 6 a.m. Pacific. Ooh, it's early. All right. And so, without any further ado, let's get into it, because we have 2,000 pages that we have to read about today. And so let's just get right to it. Donald Trump sues Judge Engoron, files a petition in the New York Court of Appeals saying that the gag order that he placed not only on Donald Trump, but on his defense team as well, as it related to this woman right here, Allison Greenfield, the judge's GF. He said, don't you dare talk about her. Don't you talk about our love notes, okay? If she wants to kick me in the foot here in the middle of trial and nudge me about an objection or something else, she's free to do that, okay? We have a very serious relationship. And so this was a wild gag order. Alina and the rest of Trump's defense team couldn't even believe it, because not only was Trump gagged, but the lawyers were gagged, and the lawyers were gagged from even objecting about the conduct. So what were the lawyers supposed to do? How can you represent your defendant if you can't even make objections about the misconduct that's taking place in the court? It's basically insane. And so what happened was there was this emergency proceeding, and we started to unpack all of this on a prior segment here, but we now have the actual lawsuit, right? This thing was filed. This is what caused the gag order to be lifted, to be stayed for an interim period of time while they process this. This is a 2,000-page document. We're going to read through the highlights of it, really hit the crux of the petition, and then look through some of the transcripts. But it is big, and this is really what's going to be debated, all right? So Tish is going to respond to this. Judge Engoron has been ordered to respond to this. Like, explain yourself, sir. Like, what do you think this gag order is justified for? How do you think it's constitutional? And so we'll read through that. And Trump is also responding to this, right? Now that the gag has been lifted, he has some of his free speech back. And so we'll go through on this, but this was the original order as we saw it come down. And there was a brief oral argument yesterday, kind of caught everybody by surprise because we were still in the middle of trial with Tish. And this is what the judge wrote. He said, considering the constitutional and statutory rights at issue, an interim stay is granted. And of course, people on the left were going, oh my gosh, Trump's going to murder 1 million people tonight with this one truth post. And he did. He published a truth post at 4:44 p.m. And he said the following on his truth account. He said, Judge Arthur Engoron, affectionately here known as Areola, has just stayed by the New York State Appellate Division for the 4th time on the same case. His ridiculous and unconstitutional gag order, not allowing me to defend myself against him, and his politically biased and out of control Trump-hating clerk, okay, that was illegal. He got fined for that twice already. $5,000 for the first offense, $10,000 for the second offense. The Court of Appeals currently has everything stayed, right? So it's not that he's going to get all that money back or that he's been found to be victorious. But the judge said, what I'm seeing at this point is a pretty big problem. And now he's right back out there talking about the judge's GF, the judge's Greenfield. He says, who is sinking him and his court to new levels of low is a disgrace. And by the way, she was the same person who donated over $3,000 to Democrat causes. Democrat causes, by the way, which were opposed to Trump, supportive of Biden, and even supported Tishy Latish James. Now, here they are defending, they say, the worst and least respected attorney general in the United States called Letitia James, who is a worldwide disgrace, as is her illegal witch hunt against me. The radical and unprecedented actions of Judge Engoron will keep businesses and jobs forever out of New York State. I have done nothing wrong. My numbers were low, not high, talking about his valuations. I have a complete disclaimer clause, and the disclaimer clause, of course, says, hey, when I provide you my financial statements of disclosure to the bank, so Trump says, this is what I'm worth. I need a loan. This is my collateral. I need this loan in order to finance this deal, and here's what it's worth. But in that document, he says, you can't trust this document, okay? This is like my interpretation. You know I'm Trump. I like big numbers. I round things up. So do your own due diligence. If you think that this is worth, a $2 billion loan, well, you can give it to me, but that's on your due diligence. This is like my analysis, my assessment. I disclaim everything in here. And in addition to that, Trump explains that their star witness, Michael Cohen, who is a convicted perjurer, he admitted he lied, and he made up this fake case against me to get the whole thing started, which they admitted. And the attorney general used a, quote, get Trump platform. That's Tishy Latish. You know her from her facial spasms, where she says illegitimate president for all the time when she was running to prosecute him. She ran on a get Trump platform to run for the AG and for governor, and she failed on that one. Now, this wicked attack on democracy must be ended now. And so, of course, this is new, right? So Trump now is actually talking about the law clerk. And again, people are like, oh my gosh, she's probably going to be dead in any minute now. Somebody protect her. Send the FBI over there. So, this is Trump responding to this, as is his right? He is calling out what he believes to be misconduct in the court, and it certainly looks like that based on what we've been seeing, right? This is Judge Engoron. He's got her on the same bench. Remember, she ran for office. She wanted to be a judge. She's LARPing, live action role playing, trying to pretend to be a judge. She is not a judge. Judge Engoron probably is not that bright, so he needs kind of a second in command. So the whole thing is totally askew, and Trump has filed this petition in the Court of Appeals, which of course at this moment has been granted. And so we're going to go through the full thing and see what they're asking for, which is basically a reversal of the gag order. But they're also going to be using this, right, in support of their motion for a mistrial. And the mistrial is going to be asking that the whole case just be dumped, basically redone, because it is unsalvageable. There's nothing else that we can get into. And so we're going to jump right into this Court of Appeals opinion. But first, let's hear this quick message from our friends. We have live stream privilege here, so we're going to fast forward that and jump right into it. This is the petition. Notice of petition. Donald Trump as the petitioners, but look at this. This is against the judge, Judge Arthur Engoron and Letitia James, right? He's specifically calling out the judge here, and the judge is going to have an opportunity to respond. Why are you doing this gagging, and why are you treating your courtroom like it's your little high school play? So they say, all right, your honors, this is going to the appellate division. So we're going up above Engoron to get into his boss essentially. And they say, let's get to it. They say, we're asking the court for a judgment, granting the relief in the verified petition. This is what we want. On the first cause of action, we want you to annul the findings of contempt that the judge issued in October. Annul and vacate their order, and do the same thing for the November 3rd date. Okay, so we've got two dates in there, 26th and the 3rd and the 20th. So three different kind of causes of action for three different violations: contempt, contempt, and contempt. I think there was a warning in there, then there was a $5,000 fine, and then there was a $10,000 fine. So they want all of that reversed. And here is what they say. And look who signed off on this. It's Alina. Haba. We got also Clifford Robert, who also signed off on the document. Now, this is their verified petition. They say, all right, judges or judge, I think it'll be heard by a panel once it is certified and everybody has their responses. But here they say, all right, Court of Appeals, regarding Judge Engoron. Now, the assumption that respect for the judiciary can be won by shielding judges from criticism wrongfully appraises the character of American public opinion. Right? Said another way, if you try to shield the judge from criticism, you're getting it wrong. For it is a prized American privilege to speak one's mind, although not always with perfect good taste, on all public institutions. We like to talk about these things. Now, and unenforced silence, however limited, solely in the name and preserving the dignity of the bench, would probably engender resentment, suspicion, and contempt, much more than it would ever enhance respect. This is what they understood back in 1941 in the United States Supreme Court. Yeah, obvious, okay? If you say we can't talk about it, we automatically presume that what you're doing in there is untoward, right? It is corrupt because you won't let us see it. We have a default presumption of access, right? That we can speak about this stuff and see it. And the people who are being punished can communicate to us about this stuff, and we can be the judges of whether it is legitimate or not that's taking place in there. But when you just try to say that you got to protect your own process and that we can't be involved in it, yeah, you're dang right. Resentment, suspicion, and contempt. 100%. And they're doing it to themselves. As we said here, if Trump was really an insurrectionist, okay, if Trump's really a monster and all these things, first of all, we could see criminal charges for it, right? If Trump actually was causing or actually harassed people, charge him with another crime. You've already done it 4 times, do it again. But they won't, because it's not actually harassment. It's not actually threatening. They're trying to make him responsible for third-party conduct and third-party behavior, which is insane. So petitioners, they say, so they can't do that, right? So they got to gag him, and they got to do it in the name of protecting the process of the court. Of course, they want to protect the process of the court because the process is corrupt, and we can see it, and they don't want us to call him out and interrupt it. So they tell us that petitioners bring this proceeding, this is Trump's team appealing this, to redress Judge Engoron's serious and continuing violation of the procedural and the substantive rights guaranteed to them under the law. Now, the conduct at issue here arises from the ongoing highly publicized trial of Trump, pending in the Supreme Court. Now, on the second day of trial, Judge Engoron entered a gag order forbidding petitioners, that's Trump and co., from posting, emailing, or speaking publicly about any members of his staff. This is known as the gag order. Then a month later, he expanded the gag order to then include the lawyers. Trump's lawyers from also making any public statements in or out of court that refer to any confidential communications in any form between, quote, me and my staff, his Greenfield, who is passing him love notes and maybe other things. We don't know. They were gagged from talking about it. The gag orders unconstitutionally infringe on Trump's rights, and they say Engoron may not, by judicial decree, transmogrify, and we wanted to look up that word, transmogrify. And I believe that word, yeah, it's to change thoroughly into a shape or form. There it is. Often greatly with grotesque or humorous effect. Okay, so transmogrify the court's summary contempt power into an unfettered license to inflict public punishments on a defendant for Trump's out-of-court statement made for the benefit of the Fourth Estate. Nor does the court's summary contempt power, Engoron's, authorize the court and its staff to actively and independently investigate, prosecute violations of a gag order. They say Engoron here and the enforcement of the gag order has violated multiple sections of the judicial law. His extraordinary expansion of that order both limits and it chills the advocacy on petitioner's behalf and precludes counsel on pain of contempt for making a record of misconduct and bias in the public courtroom. And this is where the judge told Christopher Keese, don't do it, Chris. Don't you file it. He's like, I have to, Judge. Like, that's how this works. He's like, oh, yeah. Okay. Now, prior restraints, they say orders that suppress speech based on content and viewpoint, they are presumptively invalid. Like, the law has already just said that. If you're going to try to censor somebody and silence them from saying something, it's just presumptively invalid. Why? Because the First Amendment exists. Only a clear and present danger of a serious and substantive evil can justify such an infringement on the freedom of speech. Now, the constitutional protection is at its apogee where the speech in question is core political speech made by the frontrunner and the Republican presidential nominee regarding perceived partisanship and bias at a trial where he's subject to hundreds of millions of dollars in penalties. The speech giving rise to the gag order, which was a post on Trump's social account, True Social account, was a photograph of Judge Engoron's principal law clerk and the Senator Chuck Schumer. He said that she was Chuck Schumer's girlfriend and that she was running the case against me. Now, Trump's people say, by the way, she was the one who originally posted that photo of the law clerk and Senator Schumer on her public Instagram account when she was running for judge. The account explicitly linked to her unsuccessful failure 2022 campaign for the Democrat nomination. So she wanted to be a judge, didn't win, and now she's pretending. It was then reposted by a public Twitter account called Judicial Protest, and then ultimately reposted by Trump. Now, it's apparent to anyone that's been attending the trial or reading contemporaneous press coverage that the law clerk, the judge's GF, plays a visible role in the trial, as she sits immediately adjacent to Judge Engoron on the bench, and she consults with him on almost every ruling, passing contemporaneous notes. Now, they say that Engoron has also sanctioned Trump under the gag order for a comment that he made saying that somebody is very partisan sitting next to the judge. They say completely disregarding, they called Trump to the stand. Were you talking about my law clerk? He said, no, I was talking about Michael Cohen, not the law clerk. And the judge said, no, I don't believe you. I don't think you're legitimate, and fined him again. They say on its face, Court of Appeals, the gag order prevents any speech, no matter how innocuous or relevant, about any of Judge Engoron's staff, not only just his GF, but everybody. Now, as applied to Trump, it also prevents a presidential candidate from commenting on the public conduct and the possible ethical violations of what's happening in his chambers. Now, they sit right beside him on the bench throughout trial as well. Now, while the desire to protect his staff may seem understandable, you can understand that, certainly, the gag orders as intended are not narrowly tailored. The mere potential that speech may anger or provoke others likewise does not entitle Engoron to suspend wholesale the rights that are afforded to litigants by the Constitution. The First Amendment does not permit Engoron to restrict this speech based on the audience's anticipated unruly action, otherwise known as a heckler's veto, right? A heckler in the crowd can stop the whole performance because he's offended, right? Oh, no, I'm hurt. Well, I'm sorry that you feel that way, but don't listen to the show. Like, get out of here, right? Like, the rest of the audience is not going to be harmed by your speaking out, by your being offended, right? A heckler can veto the whole thing because some third party reacts a certain way and everybody has to react to the third party. The supplemental gag order, which prohibits lawyers, not just Trump, but lawyers, from making any public statements, even in the courtroom, right? They couldn't even say it in the courtroom, like no objections. He says, you can't talk about anything that refer to any confidential communications in any form between me and my staff. And that is like, man, the lady doth protest too much, man. What are you so upset about, Judge Engoron? If this is all legitimate, then let him bring it up. But that they can't comment on it? It's like, whoa. Now, in the weeks after the gag order was entered, counsels for Trump repeatedly brought this up with Engoron, and they observed on the record the principal law clerk's unusual public presence on the bench. Look, the unusual constant note passing, love notes, eye rolling, facial expressions, visible role in the proceedings, and that's just what we could see above the bench, okay? All right, they're up there a little bit. She's on the same level. We don't know what's happening under the bench and under the table there. Now, I don't want to presume anything, but I'm just saying we don't know. I'm just making an observation. And the people in the courtroom, they moved the camera, okay? After we could see it on the camera, they moved the camera around too. So we don't really know what's going on under there. Now, counsel's advocacy comported with their ethical obligations to competently and zealously represent their clients, and how can Trump's defense say anything if they're gagged? Now, in closing the record to any further commentary on the judge's GF, the gag order insulates Engoron from contemporaneous criticism and denies Trump and the appellate courts. Okay, so they're also stealing it from you, Mr. Court of Appeals, because you can't see what's on the record because we can't even object to this. Trying to hide it. Indeed, Engoron has gone so far as to have his courtroom camera angle adjusted. He doesn't want you to see what's happening under the table, I'm telling you. Now, which now no longer reveals the collaboration between him and his GF while on the bench, and has instructed counsel that they cannot make an oral motion about the principal law clerk. Literally, don't talk about my GF. Now, the supplemental gag order also runs afoul of the black letter law mandating that absolute privileges attaches to in-court statements by counsel. Like, you can't punish us for doing our job. But Engoron's enforcement of the gag order, they say, is plagued by myriad procedural and jurisdictional infirmities, and he has consistently violated the judiciary law and the rules of this Court of Appeals. They say Engoron has twice invoked his limited summary contempt power to level punitive fines against Trump, $5,000 and $10,000, for purportedly contumacious. What the heck kind of words are these? Contumacious. Man, these are some $3 words here. Stubbornly disobedient.
Contumacious.
There you go. Contumacious. Conduct that indisputably took place outside of the courtroom, and Justice Engoron's immediate view was never raised by any party to the proceeding, let alone by motion on notice. Now, Judge Engoron did not explain how the conduct, which consisted of an archived post on the Trump campaign website and comments to the media, how did they come to your attention, Judge? Is somebody complaining about these? Or are you just scrolling around, briefing and preparing for your newsletter with your areolas? We don't really know. Nor have any of his putative sources been entered into the record. So we don't even know where these came from. Who is the complainant here? Nor have any of the sources actually even come on. So these circumstances imply that Judge Engoron independently reviews press accounts, he's scrolling, about the trials, and he conducts his own unprompted internet research into Trump's speech. You're busted, Trump. I'm following you on truth. Such activities dehors the record and particularly inappropriate given the Supreme Court, in this instance, is the sole fact finder, which concomitantly imposes elevated duties of impartiality and fairness towards all litigants. There is no public record to support a summary finding of contempt. And likewise, Engoron, his so-called evidence is his own testimony that describes the proximity to his law clerk and the layout and the bench of the witness box. He's like, well, we're not that close. We can't really touch each other that much. Unidentified statements describing a witness by his name. Yet another out-of-court statement to the press preceding the issuance of the gag order, and the Oxford English Dictionary was plainly inappropriate to justify a contempt finding. Right? So it's out-of-court statements, some unidentified witness, and his own testimony. It's like, no, we need more than that, Judge. Additionally, while Engoron has never identified any actual statutory authority for punishing Trump, his findings do not comport with the procedural nature or substantive requirements for any of these contempts. In fact, all those considerations were wholly ignored in this case. They say Engoron and the imposition of conceitedly punitive fines of $5,000 and $10,000 is far in excess of statutory limitations applicable to both types of contempt charges. Now, they say finally, inasmuch as Engoron viewed the purportedly contumacious, stubbornly disobedient statements, Trump's stubbornly disobedient statements, as impugning his integrity and that of his staff, it was error for Justice Engoron even to preside over the subject contempt proceedings. He should have delegated it to someone else. Engoron accompanies each abuse of his authority with a warning to President Trump that things are going to get worse for you, buddy, apparently until he imprisons Trump without abiding by any of the procedural protections to which Trump is entitled by law. Well, of course, it's a show trial. I mean, yeah, they don't care. Engoron's abrogation of Trump's rights during a presidential campaign and Engoron's egregious and continuing abuse of the summary contempt power in a trial that has captured the attention of the nation and the world cannot be overstated. The imposition of gag orders and the continued enforcement of them exceeds his jurisdiction and violates the Constitution. His imposition of summary punishment exceeds his jurisdiction, violates judiciary law and the rules of this court, constitutes an arbitrary and capricious exercise of the Supreme Court's contempt powers. And accordingly, Trump requests this court annul and vacate the gag orders and the contempt findings and prohibit the enforcement thereof. Now, as you can see, this is a 2,000-pager document. And so we're going to fast forward through a bunch of it, but I just want to show you kind of what's going on here. They tell us about the facts. We know when the first gag order was implemented. It was through the True Social post. We also know that Engoron and his law clerk have been working together for quite some time. She was appointed in 2019 and has been working with him ever since. So they've got a nice relationship over those several years. In 2022, she tried to run for a Democratic nomination to the civil court in Manhattan. She wants to be a judge. Now, in connection with her campaign, and while serving as his law clerk, she created and maintained a website, an Instagram account, and a Twitter account called Greenfield for Civil Court. Now, they say that this was maintained as a public page throughout the time of Trump's True Social post. Beginning early 2022, she used this account on Instagram to post a bunch of pictures. On February 26, she posted a page that she was withdrawing from the Democratic primary, not doing so hot. But she continued to actively post on there. She was showing her political activities with things like the Village Independent Democrats. And she said, petitioning with Village Dems who've endorsed certain candidates. We also know that Engoron allowed his law clerk to make some serious donos. She contributed over $3,000 to Democrat organizations in 2022 and $900 in 2023. Those are prohibited contributions. And in fact, some of those contributions went to actively support Tishy Latish, the AG in the case. And they also went to oppose President Trump. And the case was pending while she made those donos. She also attended partisan political events literally while this case was pending, where speakers openly advocated for Joe Biden and commented on the fight against development for the profits of real estate. We also have photographs of Engoron's law clerk, his GF, at the Chelsea Reform Democratic Club. And look, she's having brunch with Schumer. Schumer's no fan of Donald Trump, is he? This is the judge's principal law clerk, known as Allison Greenfield. Greenfield, the judge's GF for civil court. So thrilled to attend the Chelsea Reform Democratic Club founders brunch today, honoring incredible and fearless lifelong public servants like Senator Schumer and Rep. Maloney. Nah. Isn't that nice? Here's Schumer. These two belong together. Gosh. Now, that's curious, okay, because she's co-presiding over a case involving Trump. They say on September 27th, the principal law clerk called Greenfield the photo was used in a post on an online platform called X. This is the photo from judicial protest. They said, why is Judge Engoron's principal law clerk, Allison R. Greenfield, palling around with Chuck Schumer? Hey, great question, judicial protest. At judicial protest. The original post remains visible on their page. Now, the same page routinely posts photographs of other people and other media about the principal law clerk, and the photographs and the posts have generated millions of views. So then Trump took the same post, posted it on Truth. He said, Schumer's girlfriend, Allison Greenfield, is running this case against me. How disgraceful. This case should be dismissed immediately. And then Trump reposted the link and he said, Greenfield for civil court, the same account that the clerk urged her followers to keep an eye on. So after learning about President Trump's repost outside of his courtroom from an undisclosed source, we don't know who told the judge about this. Maybe it was Greenfield herself. Was it her? Did somebody say, hey, Trump's posting about you, and she told the judge? Hey, I don't like this guy posting about me. Can you gag him, honey? Justice Engoron conducted the above reference off-the-record conference. Despite Trump having constitutionally protected speech, Trump voluntarily and immediately deleted the repost on his own because he's a nice guy. But later that afternoon, Judge Engoron, sua sponte, okay, meaning the government didn't ask him for this. Tishy Latish and her bureaucrats didn't ask for this. The judge just decided, I'm going to do it. He entered an order prohibiting all parties from posting, emailing, or speaking publicly about any members of his staff. A copy of the so-called transcript is right here. He said the following. A compiled transcript says, Judge said this about Trump. This morning, one of the defendants, Trump, posted to a social media account a disparaging, untrue, and personally identifying post about a member of my staff, which was her post. Okay, in a public post. Personally identified, she posted it. Although I have since ordered the post deleted, and apparently it was also emailed out to millions of other recipients. Personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstances. Yesterday, off the record, I warned counsel of this, and it was disregarded. My warning was disregarded. My GF is upset. Consider this statement a gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff. Any failure to abide by this directive will result in serious sanctions. Little Engoron, right? Very, very, dictator-like. So Judge Tanya Chutkan, of the D.C. court, who they are parlaying off one another, right? They are stepping on each other's shoulders on these cases. She imposed a gag order on Trump. She did the same thing. Now, that gag order was also extremely short-lived. A 3-judge panel in the D.C. circuit, which we'll talk about in the next segment, administratively stayed the gag order pending appeal. Now, they say that the imposition of gag orders on Trump has been widely criticized. Even the ACLU is joining in on this. And before Trump voluntarily deleted his post, it went out on an email. Now, that email was automatically archived on Trump's website. Then, the law clerk, again, based on information obtained outside the record, the law clerk, she emailed them, again, based on information, emailed the parties on behalf of Judge Engoron that he had learned that Trump's deleted True Social account was still active on the website. A copy of that email sent by the principal law clerk is attached as Exhibit E. Oh my gosh. Okay, so she sent. Now, all right, this is a monster document. So I was going to try to pause down and find Exhibit E, but this is a 2,000-page document, so we're going to hold off on that. So they say that the point is, literally, Greenfield, the law clerk, is sending the email. Hey, you have my post still up there in violation of the judge's order. That's like her she's talking about. So the archived email and the Truth Social post were deleted the same night. They showed up the following day. They said, Your Honor, it was inadvertent. Nonetheless, sua sponte, again, on the court's own volition, nobody's complaining about it, unless it's Engoron's GF who is. She says, you got to do something about this. He's like, okay, relax, I will. He goes out and he says, okay, first time violation, a nominal fee of $5,000. He says, Trump's rich, you can just pay it. So then he issued an order. He said, he continued, he said, we knew that this was on your website for 17 days. And if you do this again, there's going to be more serious sanctions. Now, Engoron, puzzlingly, referred to contempt as a future sanction. He called it a sanction and failed to reference any authority for the punishment that he imposed. He just said, I can do it. However, inasmuch as the order found a violation of the gag order and immediate punishment, it constituted a summary punishment for civil contempt pursuant to the law. So then they tell us about the second contempt finding, and this is Michael Cohen being on the bench. And here is what the bench looks like. So check this out. They say the principal law clerk, Trump made a statement about the person sitting next to Engoron. Now, the principal law clerk sits at the bench with Judge Engoron to his right-hand side. The principal law clerk has sat at the bench during pretrial proceedings for the duration of the trial. The arrangement is depicted below in the photographs published by Getty Images and the AP. These aren't our photos. These are your photos. And they're like two little lovebirds up there. I mean, it's like it's like your colleagues, like literally like colleagues, right? She's sitting there, maybe even showing him his computer, handing him things, looking at him. It's very, very close. Very close. And here's another image right there. In fact, she's looking at the computer more than the judge is. All right. Like this, look how this computer is even angled, right? It looks like it's to her, not to him. Clearly, it's definitely angled more that direction than that direction. And she's basically running the show. Okay. He's just sitting up there as, the gray hair. That's it. And so here we see the principal law clerk is given unusual latitude for a court attorney and often questions attorneys for the parties herself. Engoron turns to speak with her off the record during trial before ruling on virtually all evidentiary objections or answering questions about the court's position on various issues. And so, they have, mic mute, so they're talking, and then the mic comes back on, and then they, will carry back on the record, so nobody can hear them. So the principal law clerk, the role in the proceeding has also been the subject of significant on-the-record discussion. For example, on October 25th, Trump's defense, Mr. Keese, he described the, quote, considerable tension caused by the law clerk's position on the bench. And he said, it's unusual for a law clerk to sit on the bench. That's for the judge. Now, and judges work very hard to get on the bench. Mr. Robert, they have to run, get elected, right? And she didn't do that. So Mr. Robert described his experience in New York State. He says that he had never had a situation where you're literally trying the case to two judges. He says notes are constantly being passed. It would appear the court is in consultation with the law secretary with each ruling. He further described that Engoron would appear to be leaning in one direction and then will get a note or there will be an eye gesture or a roll of the face or something. Abba said, if we're going to make a complete record with the treatment that I've received from the law clerk, it's inappropriate. I don't like having eyes rolled. I don't like being yelled at by law clerks who did not earn the robe. Yeah, Alina, woo! Man, that's right. She is not a judge. She did not earn the robe. She's LARPing. She's live action role playing. You got no business talking to me like you're a judge to me. Now, in sanctioning President Trump under the gag order, Engoron found that Trump's recent statement was a blatant, dangerous disobeyal of his gag order, even though he was talking about Cohen. Engoron responded that he would typically interpret, Engoron is so preloaded on this thing, man. He's triggered. If you just say, anything about like the courtroom, he's like, are you talking about Allison? Huh? He's just triggered. He said, alongside of me means my GF. Now, the matter did not come up again during the duration of the morning session, but then Engoron conducted an off-the-record conference with the parties, which was closed to the press. Nobody could report on it. Then which was off the record, and who knows what he said. So Engoron then permitted the public to re-enter the courtroom, and he went back on the record to resume the discussion. He said, we're going to hold a hearing right now, and I'm going to call Donald Trump as my first witness. And we were here, we go, what? He called him up. Engoron proceeded to instruct Trump. He says, sir, come on up to the witness stand. And he had him swear him in. Just ask him questions. President Trump, he said, what did you mean when you said? And Trump said, what are you talking about, Judge? The person sitting alongside of you was Cohen because he was on the witness stand, seated right there. Says, Engoron proceeded to challenge Trump's response. He said, I don't believe you. Are you sure that you didn't mean the person on the other side of me, my principal law clerk, Trump? Trump says, yeah, I'm sure. Have you in the past referred to her, my principal law clerk, as partisan or a partisan Democrat, Trump? He said, maybe unfair. I think she's very biased against us. I think we've made that clear. We put up the picture and you didn't want that up. I think they got it off her website, however. So we didn't necessarily agree, but we did take it down, Your Honor. And then Engoron began ripping off on this. He began testifying on the record, right? The judge is explaining himself. Like, judges don't have to do this. They don't have to go through all of this. They do this because they're doing something unorthodox, right? This is not normal. So then he starts opining about his physical proximity to his principal law clerk, which is like, Engoron says, well, I'm more interested right now in to whom you were referring, as you can see, and as everyone can see. First of all, my principal law clerk is very close to me. We know, we've been seeing it in the photos. In fact, he says, Miss Abba would refer to the notes back and forth and even the conversations between us, but you and I, we can see each other and we're close, but not as close clearly, and there is a barrier between us. Okay, so this judge is like burying himself in this. He's trying to get Trump, to pin Trump on this idea that Trump was talking about Greenfield. And so the judge is making the argument. He's saying, no, you were talking about Greenfield because we're so close. And how do I know we're close? Because I'm passing notes to her, and there's a barrier between you and me, and there's not even a barrier between us. I mean, her hand is basically on my knee right now, as you can tell. And everybody's like, that's what we're talking about. Yeah, exactly. Yeah, exactly, Judge. Thank you. Dum-dum. Thank you for proving our point. She is very close to you. She is referring notes to you. And there is not a barrier between you, and there should be, because the law clerk sits below you, and there is a barrier on the other side generally, because they are not on the bench like a judge. So Engoron, he's like explaining this. He then punctuated his testimony with a question to Trump. He says, so wouldn't that be at best somewhat ambiguous as to whom you are referring? This is one of the dumbest judges you've ever seen. Aren't you trying to be ambiguous? He says, don't you always refer to Michael Cohen as Michael Cohen? And Trump said, no. Sometimes I call him, whatever. Now, at the conclusion of his star chamber questioning, Engoron, acting as both the prosecutor and the jury, he declared that he believed none of President Trump's testimony. And he imposed a second summary punishment for violation of the gag. Engoron says, as the trier of fact, I find the witness, Trump, is not credible, that he was referring to my law clerk, the principal law clerk, who is sitting much closer to me, who doesn't have a barrier, we know, whom I believe has been accused by Trump as being a partisan Democrat, which is true, as she is, because she donated $3,000+ and also ran as a Democrat. I hereby fine you $10,000, which is on the low side, to be paid within 30 days to the Lawyers Fund of Client Protection. Because you offended me. Now, in a written order, Engoron memorialized the findings, and he said, quite clearly, defendant was referring once again to my principal law clerk, who sits alongside me on the bench. Now, Engoron then reiterated that Trump's testimony under oath rings hollow and untrue. And what he did is he went to the Oxford Dictionary, and he said alongside means close to the next of. And he said witnesses do not sit alongside the judge, they sit in the witness box. In contrast, the principal law clerk, they're rubbing his nose in this. It's so good. They're rubbing his nose in it. They say, by his own repeated characterizations, even the judge is admitting in his own written orders that the law clerk sits very close to him during trial. And so all the Court of Appeals judges are like, wait a minute, what? How close? They're all thinking about their law clerks. They're like, oh, how close do I sit to my law clerk? I wonder why she doesn't sit that close to me. Justice Engoron further rejected President Trump's testimony because he made past public statements about Cohen. And he said, well, previously, he calls Cohen by name. And then he said that the statement mirrored other language, and so he sanctioned him. But he said that the statement was unmistakably clear. Now, he didn't cite any statutory authority for the punishment. Why? There is no authority. However, inasmuch as the order found a violation of the gag order, it constituted a summary punishment for contempt. So then, Trump and his team, they submitted on the record entry of the gag order. They objected on the record to entry of the gag order. They said there's no evidence to support your assertion. They said, Your Honor, Trump has a First Amendment right. He can comment on what he believes and perceives, I think legitimately from his perspective, as a potential source of bias. And limiting Trump's speech runs afoul of the First Amendment in general with respect to the defendants, but also even more under the heightened scrutiny of restricting and placing prior restraints on political speech. And they said, Your Honor, we need this gag order reduced to writing. We're going to be appealing this. And they did. So he wrote a total new order, and President Trump wrote to the court, says we are going to be appealing this, which is what we are doing now. On November 2nd, Engoron and counsel engaged in an extended on-the-record discussion about the principal law clerk and the gag order. A copy of the transcript is attached. But Engoron resorted to an ad hominem attack on counsel. He's name-calling him as follows. He said to Mr. Keese, this is Judge Engoron speaking, okay? And a lot of this stuff doesn't make it to the excerpts that we review here, of course. He said, Mr. Keese, Engoron, all joking aside, and even I like to leaven the proceedings, maybe lighten, do not refer to my staff again. A person sitting alongside of me is my principal law clerk. She's a civil servant. She's doing what I ask her to do, which is help me process cases and decide them correctly. Sometimes I think there may be a bit of misogyny, Chris. The fact that you keep referring to my female principal law clerk. If there is any further reference to anyone on my staff, and I don't have a big staff, I have about 3 people, I will consider expanding the gag order to include the attorneys, including yourself, Chris, Mr. Keese. Mr. Keese responded. He says, Your Honor, I do often feel frequently like truly that I'm fighting 2 adversaries, and I'm not trying to impugn anyone. I'm trying to point out as a lawyer, and I think it is a fair comment as a lawyer. I understand what your ruling is, but I have to respond to this because this is important. So I feel like I'm sitting here and I have to respond to Mr. Amir and their arguments. I hear what those arguments are, and I get to see what those arguments are, and we get to have your engagement. But then there was someone else who is sending you information on a very, very frequent basis. I think yesterday we counted 30 times, maybe 40 times. And so I don't get to understand what this is. And those, I'm not trying to invade it. All I'm trying to say, Your Honor, is that it gives off, respectfully, that gives off the appearance of impropriety. And I'm entitled to at least make a record about that. It is not impugning anyone. It does give off the appearance of impropriety, particularly if it is an individual or individuals that have a different point of view on the case than we do, have a different political background or political view than we do. And so those are relevant issues for Your Honor's consideration. Again, this is why I brought it up on the constitutional. I ask you to reconsider the gag order on the constitutional basis because I think it raises much more serious issues, and I don't really want to go there. And I'm not trying to, but at some level, I have to at least have fair comment on what I think is biased. Abba continues, Your Honor, I would be happy to make the record for Mr. Keese so that none of her team members, my team members, Alina, are accused of misogyny. Do you want me to make these objections? I'll make these objections. And she said, I have the same issues with the person sitting on the bench. Your Honor, I respect your position, but I do feel like, Mr. Keese, that your position is often what you are given in notes, and we don't have a clue what is going on, but we do know that there is a nod of the head by you when those notes are received and then decisions are made. We have to make a record of it because, frankly, it's become part, and I've said this for 3 years for me personally, a part of the record. And I'm not going to stand by and allow it to happen. I'm not going to let someone who's my teammate be called a misogynist because he is pointing out something, frankly, that I can do myself. So I will make my own record, she says. It is inappropriate. Shout out to Alina. Now, defending her co-counsel, Christopher Keese. Yeah? Call him a misogynist, call me a misogynist. Now, after further discussions of the witness testimony, Mr. Keese stated that I have to, on behalf of my client, comment on what's going on in this courtroom that I think could prejudice or bias the proceeding. Keese said, I don't see what is being passed to you, so it is not possible for me to know. Now, Judge Engoron became irate. Okay, now he's furious. How dare you? That's right, he says. You don't see it. I'm going to pound the table. That's confidential communications from my principal law clerk. Absolute right to it. And you don't have any right to see it or to question it. Keese says, I certainly have a right to question what is perceived by my client as bias. I do have that. I have to make a record. I do have that. That's just what lawyers do. I mean, I have to make a record. I don't think, respectfully, there is any security concern. We're talking about observations of what's happening in open court. Everyone in this room can see what I'm seeing. So it's not a security issue. I'm not commenting inappropriately. I'm directing my comments to you and only to you, but I have to make a record if I perceive that there is a potential bias. Shout out to Christopher Keese and Alina Abba. Now, on November 3rd, Justice Engoron then opened the proceedings with further comments on the principal law clerk. He says, not yesterday, but several days ago, I believe that one or two or all of the defense lawyers said that they had never seen a judge be so intertwined with his or her law clerk, basically passing messages. I mentioned that to the judge for whom I was a law clerk for many years, and he reminded me something that happened many decades ago, saying, there was an elected Supreme Court judge, which is what I am, in this very building, and I'll give away the genders. He was very well respected, and he had very high-profile cases. Now, if I told you the name of the plaintiff and I told you the name of the defendant, everyone would know them. Now you're scratching your heads, right? Now, the law clerk was running for the judge, and the campaign literature said, I'll almost quote this exactly, says, I sit on the bench every day with the judge and I whisper in his ear and I tell him how to rule. Now, of course, we haven't seen that, fortunately. The law clerk was elected, is still a judge. This is decades ago. And so just to claim that you've never seen anything like this, apparently that's even more extreme. Now, I didn't see this happen. I'm assuming that's what the story was, and the judge never said so. She doesn't sit up there and tell me how to rule, but to finish up, I hope I made myself clear yesterday. That is a weird story, man. So he goes back like decades and like digs up this story about some clerk who says she whispers in the ear, and he's like, so it has happened before. Anyways, later, the court issued a gag order later that day. Now, after describing the two instances of summary contempt, he then imposed the gag orders upon the parties. Now, he says that's not going to go upon the attorneys. And then further clarified this later on. He says, Mr. Engoron further clarified in response to some questions from the attorneys. Abba asks the judge, Your Honor, I'll be more clear, if I may. I think that they are being extremely careful and it's causing confusion, Your Honor, so don't sanction me. I'm doing this in the most delicate way possible, but Alina says, Your Honor, we know that we are going to be moving for a mistrial, just so you know. There's no, that is part of the plan. We don't want to put anyone at risk, which is what they are trying to get at. Now, outside in the way I read your order, which is different than they do, I think that you are specifically speaking about the contents of your notes being confidential. And that is what we are not to talk about, right? It's the content of the notes we can't talk about, right? He says, no, not just the contents, which I assume you don't know, but the fact that they exist. You can't even talk about the fact that they exist. Alina says, okay. He says, that's my business, not yours. So then Trump's lawyers, they asked Judge Engoron, does that mean that we could not refer to communications even if they're a necessary ground for a motion? Like we can't even put that in a motion? Even though you've not heard these things? Like we have to create a record. That's why it's all on the record. So Trump's defense says, Your Honor, like, okay, so you say we can't even talk about, but okay. So, Your Honor, of course, but if we were, for example, if we were to move for a mistrial based on the implications of what you just said, that we would need to at least reference the subject matter in order to file the motion. Like we at least have to talk about the notes if we're going to file a motion for a mistrial. He says there's no way to file that motion without referencing the subject matter. He says, we don't. The judge cuts him off. Don't file that motion, Chris. Don't file that motion, Chris. Don't. Chris is going, I'm a lawyer. Engoron confirmed that he was directing counsel. Okay, that's an order from a judge. It's an order. not to make any motion based on a ground that might be subject to the gag orders. This is the judge doing this all on the record. This is going to the Court of Appeals. Defense says, Your Honor, for clarification purposes, I just want to be clear, then is it the direction and the order of this court, you're ordering us, that if we were to move for a mistrial based on the grounds that are subject to the gag order, you are saying we are directed to not make that motion? Is that what you're saying? Court says, can you repeat that? They repeat that phrase. He says, yes, I'm directing you not to make such a motion because I'm entitled to do what you're referring to. The only subject matter of the gag order. I'm allowed to pass notes. I've already decided that I'm allowed to do that. You can't even object to it, so don't put it into the motion. So the attorney can't make a record about something that the judge is doing that he thinks he has the power to do that maybe he doesn't. So Engoron then modified his position, right? Then he probably got a note from his GF and she's like, hey, dummy, you can't, like, they have to be able to file motions. Like, that's the whole point of why we're here. Like, this is a courtroom. Hello? Look around. Engoron then modified his position. He's like, oh, yeah. He then tells counsel, he says, okay, I guess you can make the motion, but only in writing by submission of a proposed order to show cause. So he's like, oh, I guess you have to. I guess I can't do that. So Ms. Abba comes back. She says, okay, so outside of the notes then, Your Honor, other issues have come to our attention outside of just your love notes. Are we allowed to address anything outside of notes? Because they haven't been addressed with the court, and I think that's the clearest way to ask, Your Honor, what we are asking, which is we need to have an opportunity to be heard on those things that have not yet been heard. So he says, give me a second to have a confidential communication. And he goes, that's fine, Your Honor. That's fine. Alina says, yeah, of course. Yeah, have a confidential communication. Have fun. So he probably leans over and talks to his GF. He says, okay, how's this? He says, I think this is fair. And I understand your concern. You can make that motion, Miss Abba. Thank you. And he says, I'm sorry I yelled at you before. Miss Abba says, well, we'll do it in a very delicate manner. Okay, but it has to be in writing. I don't want to hear it in front of hundreds of people. What? It's in writing. We're reading it in front of thousands of people now. And so, yeah, do it by order to show cause, please. You can make it as quick as you can. Now, counsel stated that while that procedure was highly unusual, it was acceptable and provided the order to show cause was actually signed by Engoron. However, Engoron refused to confirm that he would sign it. The defense says, Your Honor, I've never seen an application for a mistrial done by an order to show cause like that. But as long as the order to show cause is signed by the court, I guess I don't see a problem with that. He says, well, I'm not sure that, I guess that there's a brief pause in the proceedings. He says, submit an OSC. It's not an order until the judge signs it. Mr. Robert knows that. Submit a proposed order to show cause to me. I'll get right to it and make a quick return. And they say, okay, well, based on all of that, all right, based on all of that, these are our causes. So the judge is basically whacked, Court of Appeals. Here's the deal. We have a couple causes of action. And they're saying we have the right to bring this, and they're giving us the law that tells us why we can end up in front of the Court of Appeals, which is where we're at now. They say an order that imposes summary judgment under the judiciary law is reviewable by the next level court. October 20th and 26th orders were in fact contempt orders that constituted arbitrary and capricious. They were affected by error of law. They were a violation of lawful procedure. They were an abuse of discretion, and so on. The order was impermissibly imposed ex parte upon Trump. Trump did not meet the standards, and that Engoron impermissibly imposed summary judgment upon him. They tell us, same thing with October 20th. Again, improper punishment. Say here that the statutory maximum fines for these things is just $1,000. $1,000 for the first offense. He hit him with 5. So he's up. He's not even following the law. Same thing happened in October 26. The judge created his own ex parte investigation, right? He's singling Trump out, going to find out where he's violating his orders. The orders impermissibly impose punishment without hearings, without due process, without notice, without written charges, without counsel, without compulsory process. He violated the law and just sanctioned him. Now, here, another cause of action saying that he lacks the jurisdiction to even punish Trump under the power of his court. And we also have some constitutional problems. The First Amendment to the United States says that Congress shall make no law abridging free speech, and any imposition of a prior restraint to limit free speech is a problem. The gag order was explicitly identified by Engoron as a gag order. He said, the gag order stops everybody from speaking about his GF. Now, speech is unprotected where it could produce imminent lawless action under Brandenburg, but he wasn't talking about imminent lawless action. He was talking about disparaging, untrue, and personally identifying information by his own words. There was no harm, there was no threats, there was no violence. He was just upset. He was offended that someone called out his Democrat clerk. The gag order suppresses Trump's free speech on the basis of content viewpoint discrimination. It's unconstitutionally overbroad. It fails to identify any actual legitimate threat to Engoron's staff, and it wrecks Trump's First Amendment rights. It's overbroad. Trump has already been sanctioned according to this gag order, so it's not just his free speech, it's also money has perceived, and the fact finder is as biased as you can get, including moving the cameras around, playing footsie with his law clerk, including bonus torso photos and Trump stories in his high school newsletter. They say Engoron also on his own is going out and trying to find violations. In his orders, he's cautioned everybody. All the posts that Trump shared were made by the law clerk during her time as the law clerk. And one of her posts with Schumer was even made while this case was pending. Her role is very unusual. Feels like everybody's trying the case to two judges. Even contemporaneous press coverage has called this out as well. Almost every ruling, almost every decision, they're passing notes. And Engoron is constantly communicating with her throughout the trial. Now, Trump must be, as a presidential candidate, permitted to comment on what he believes and perceives. A defendant in a high-profile trial is well within his rights to comment on the actual bias of a judicial appointee who sits immediately next to the judge. But Engoron, on his own, issued a second order and blamed Trump for something that Trump says he wasn't even talking about, limiting his free speech in his conversations with the press. Nothing about Trump's comments about the law clerk or about Cohen constitutes incitement or any type of other unprotected speech. And the gag order is also attacking the 2020 Republican frontrunner. This case has relentless media coverage, and statements made by this candidate during a political speech are worthy of First Amendment protections. Engoron has issued an order that is unconstitutionally vague, and it's not sufficient to provide notice about the prohibited conduct. And so we got even more causes of action here. Now let's wrap up until we get to near the conclusion of this to see what they're asking for. They ask here, as they wrap it up, they say, for all of the foregoing reasons, the supplemental gag order from Engoron should be annulled and vacated. It's in excess of Engoron's jurisdiction under the First Amendment, and it violates the Constitution. And so they're asking the Court of Appeals to grant judgment in their favor on all four causes of action for all the different violations, saying that they want the summary findings of contempt annulled and vacated, and any other relief that the court deems just and proper. Signed by Alina, Abba, and Robert, Clifford S. Robert from Robert, and Robert all sent in and verified as an appeal. Now, I wanted to just scroll through some of the exhibits and see if we have anything interesting here, because there is a lot. You can see, yeah, it's a 2,000-page document, so we're not going to do that and give ourselves all a blindness here. But there is a lot here, and including transcripts. So I wanted to share this. Now, this PDF will be available at robertgovea.com, so you can read through the full PDF at your leisure. But there is a lot to it. It's 2,000 pages, and you can see here we do have some transcripts in there. So it's all there. I mean, it's all on the record. Like, it's all corroborated. And so that is what is taking place out in New York. Alina Abba, who filed that motion, was explaining how some of this stuff works. Now, this was an interesting exchange because this was right before the gag order was lifted. So she's talking about the motion for a mistrial, which is a motion that we read through here previously. And it's closely related to the gag order, right? Part of the reason for a mistrial is because of the gag order, right? They haven't been able to comment and do their due diligence in the middle of trial. And so Alina is explaining what's happening here from her perspective. This is what it sounds like.
Well, I can speak to the court. I can speak to the rules that need to be followed that have been broken. Generally speaking, you cannot have the appearance of bias. You cannot have, there's rules about political contributions. There's rules about doing things that show a bias towards someone. I can speak to what the judge has done, which is putting things into the Wheatley alumni newspaper that he is an editor of. There's articles about me. There's articles about Eric Trump. There's articles about the case while the case is pending.
Wow.
There are things you're just not allowed to do because the American public has to believe that when they go to court, they're going to get a fair trial no matter what their personal beliefs are. Obviously, I have my personal beliefs.
Yeah.
But if I were a judge, I'm not allowed to bring those in. You're supposed to look at law to fact. And there's a lot of evidence there, some of which I can't speak about, some of which I can, but I encourage everybody to read the papers.
In fact, in the papers, there's a video of the clerk talking about Letitia James chanting in terms of, you know, Trump is going to go down. What specifically is she chanting?
So that's the one part of my gag order that I obviously cannot speak to. I think, let me just speak about the gag order for a minute. The fact that I can't speak about it is so crazy in and of itself.
Right.
I'm an attorney, I'm an advocate, and I'm a spokeswoman. So the president's attorney and spokeswoman cannot speak about things that I see that are inappropriate because I've been gagged. My gag is limited to that item. So unfortunately, all I can say is I encourage you to go look at the papers and it'll speak for itself.
We read
because the clerk
motion.
is actually chanting. And you have reported in the past that the clerk had donated lots of money.
Yeah, that's been reported.
To Democrats.
That's been reported.
3,900.
Yeah. Alina, let me get your take on what Hunter Biden is saying now, because Hunter Biden's lawyer is calling for a federal judge to subpoena former President Trump.
Sure.
Hunter Biden says he wants a subpoena of Trump for testimony in his criminal gun case.
Okay.
In a letter to the judge, attorney Abby Lowell writes this. Mr. Trump has made a plethora of concerning public statements calling for an investigation or possible prosecution of Mr. Biden, both while in office and since leaving. Mm-hmm. Is President Trump expecting a subpoena from Hunter Biden?
You know, if they're going to put my client on the stand, and I have heard this, if they're going to put my client on the stand to discuss Hunter Biden, go ahead. Go ahead. You know, obviously, it's ridiculous. They're trying to intimidate and trying to say, if you're going to attack our kid, we're going to put you on the stand for what? Saying things that we've seen pictures of, checks that have come from the CCP, drugs, videos, hookers. I mean, I'm not really sure what their angle is there, but I would advise him to get new counsel.
Well, at this point, you've got a laptop, which basically lays it all out.
The laptop from hell.
Yeah, the laptop from hell.
So, all right. So they are going to be filing, I'm sure, more motions. Of course, the Court of Appeals from the New York jurisdiction will be ruling on this. The gag order is being challenged. Will it remain in place? Only time will tell. Of course, we will be here continuing to cover this. Things are getting a little bit spicy. Trial next week should be a lot of fun. We'll be here covering this trial and all of the other Trump trials. Thank you for subscribing. Checking out robertgovea.com, which is where you can get all the PDFs, access the mind map, sign up for our daily newsletter. That way you don't miss any segments. All the stories will be delivered to your inbox. We'll see you there and here on the next one. All right. Now, my friends, we've got another gag order to talk about, but this one is with Chutkan. And this one's pretty fun because we got 18 state AGs. Who's coming out? Hi, Alina. Bye, Alina. Okay, so let's talk about this one. We've got 18 state AGs, attorneys general, now supporting Donald Trump against Judge Chutkan's gag order. This is at the D.C. Circuit Court of Appeals, and we got this filing from 18 states. Now, of course, Trump allegedly is an insurrectionist. They don't want him to speak about anything in this case because it might jeopardize the trial. Now, what about Trump's free speech rights? Doesn't he have the right as a political candidate to get out there and do politics and speak and communicate his ideas and his policies, one of which might be that the DOJ is broken and corrupt? But not only Trump, what about our rights to hear from him and the people in the states to be able to go and vote for him and to be able to hear his perspective on the corrupt DOJ being the victim of the corrupt DOJ? And so 18 state AGs say he needs to be able to speak about this so that our rights are not violated. We'll read through the filing. We'll also hear what Kinzinger and Christie has to say about this before wrapping up with Marjorie Taylor Greene and her take on what happens if Trump goes to jail. But we have 18 state AGs filing an amicus brief, which is a friend of the case brief, and it's coming in the Court of Appeals. And this is what the docket looks like there. Out of the D.C. Circuit, you're going to see a lot of activities. We've got the Christian Family Coalition out of Florida. They're also filing an amicus. We also have here America First Legal filed an amicus. We have this one is the one we'll look at. 18 states. The states are Iowa, West Virginia, Alabama, Alaska, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, North Dakota, Oklahoma, South Carolina, South Dakota, Texas, and Utah. Now, we're missing Arizona here. We don't have a Republican AG here, unfortunately. But other states are also missing. But 18 is a pretty good number. And this is what was sent in to the Court of Appeals for the D.C. Circuit challenging Judge Chutkan. And you can see it's a 23-pager. And something's looking a little bit strange with my red pen. So let's get this brief situated here. It is United States of America versus Donald Trump. Trump is appealing this to the D.C. Circuit Court out of the United States Court of Appeals. This is the brief for the Amici, the friends of the court, the various states that we just talked about. And what are they asking for? Supporting Trump and reversal. Supporting Trump against Chutkan. The table of contents telling us that Chutkan really did not narrowly tailor this and that this whole thing is unconstitutional. Let's see what the state AGs say. They tell us that the states of this country stand foursquare behind the protections of the First Amendment of the Constitution, saying no branch of the government may abridge the First Amendment. They tell us that this right is paramount when it comes to protected political speech. It's at the core of what we talk about in this country. The district court here, Judge Chutkan, overstepped its role in issuing an overly broad order denying Trump from making public statements about individuals involved in the judicial process. The court, through Judge Chutkan, imposed limited restrictions on extrajudicial statements that hinder and inhibit an ongoing presidential campaign, particularly as applied to President Trump's ability to make statements about witnesses who are themselves a part of the campaign. Now, that overbroad order, an order that a major United States presidential candidate must mute himself on a major campaign issue, cannot survive any level of scrutiny. And when we talk about the Constitution and constitutional violations, there are different standards of scrutiny that we look at. How closely, how magnified with a magnifying glass do we look down at this thing? If it is a law that is not violating your constitutional rights, we don't look at it that closely. We just say, if you have a problem with that, go vote about it. But it's not a constitutional violation, so we don't really pay much attention to it. But if it is a First Amendment right and you're a political candidate in the middle of a political campaign and they're saying, you can't talk about politics. We go, what? We got to take a very, very high-powered electron microscope and look at that thing and scrutinize it very, very in-depth. And if we do that to this gag order, it's not going to survive. We're going to look at it and say this thing's bad. So beyond its overbreadth, meaning it's just too overbroad, it is too over-encompassing. The order is impermissibly vague. It covers a bunch of conduct, and we don't even know what it's talking about. Now, by failing to articulate what it means to, quote, target the individuals that the order identifies, their prior restraint will unlawfully chill President Trump's speech. What does it mean to target? Can he comment on it, or is that a target? Now, the states, the Amici states, the friends, all the 18 of them, they are home to upcoming caucuses and primaries. Now, as administrators of free and fair elections, we have an interest in ensuring that no illegal prior restraint is entered against major political candidates. Indeed, our citizen and us, we have an interest in hearing from major political candidates in that election. This order threatens our state's interests by infringing Trump's free speech, and so accordingly, we are filing to defend him. And by the way, this should be every attorney general in the state, in the entire country, signing on this thing. They say former President Trump is the Republican frontrunner for president. Even were he not, President Trump enjoys the First Amendment right to speak, and American citizens enjoy an essential right to hear what he has to say. President Trump is also currently the defendant in this underlying case. But that does not justify Judge Chutkan slapping President Trump with this prior restraint on his free speech. Courts, no doubt, they must ensure that they take steps to rule and regulate in a manner that will protect their processes inside the courtroom from outside interferences. We know that. But the record before Chutkan's court here, however, makes it doubtful that this court could justify any restraint, much less this one, which is both too vague and too broad. Both those deficiencies beg for this court's correction. First, while Chutkan correctly raised First Amendment concerns in its order, it misapplied the binding strict scrutiny standard, which is the highest level microscope, which does not justify issuing a prior restraint against Trump. This overly broad order cannot survive any tailoring analysis. So sometimes we'll say that we can pass a law as long as it's narrowly tailored so that it doesn't become overbroad and violate more rights than necessary. Second, they say Chutkan failed to meet the standards required to ensure its order was clear enough to avoid being impermissibly vague, telling us that courts do not presume that restrictions that curtail constitutionally protected activity, that they do as little as possible, right? We don't just presume and give them the benefit of the doubt. They actually have to be narrowly tailored. And lastly, the presidential campaign is in full swing. Iowa's First in the Nation caucuses are 62 days away, 2 months from the filing of this brief. So the election interference is already happening right now, right? We're not going to wake up in November 24 and, if things don't go our way, say that the interference occurred on election night. Okay, they're doing it right now. Like, all of this is propaganda to say Trump's a criminal, Trump's a criminal, Trump's a criminal, Trump's been indicted, Trump's felony, blah, blah, blah. And if Trump can't defend himself, the harm is happening now, right? Every time Trump is gagged and he can't comment on these illegal prosecutions or these unjust prosecutions, that is him being harmed. That is the election being interfered with. It's happening right now. Just like we saw about this time in 2019 rather, we were seeing all of the election litigation be filed, right? All of the COVID rules were changed because of COVID. We need to move this deadline and collect ballots and do all these things. Happens well before. It's happening right now, right? And they're gagging Trump as part of that effort. So as Americans turn their attention to the upcoming presidential election, there should be special care taken to ensure that they can judge the candidates on their own merits. Entering a prior restraint that may limit a candidate's ability to campaign must meet the exacting standards. Now, this court did not narrowly tailor its prior restraint. The order prevents, quote, all interested parties, including the parties and their counsel, for making any public statements that might, quote, target the team, counsel, staff, or this is the most broad one, any reasonably foreseeable witness or the substance of their testimony. Like, what the heck does that even mean? Means whatever you want it to mean. And it means everything and nothing. So Trump can't say anything because of that problem potential. It purports to find that President Trump and his counsel, his lawyers, quote, pose a significant and immediate risk of prejudicing the process. Well, they would prejudice the process by exposing the process, which might prejudice your process, but not a just process. We want a just process. We don't want a corrupt process, which is what we're watching. So in doing so, the order fails to be the least restrictive means to further the government's ends, and thus it fails to satisfy the strict scrutiny standards. The court's analysis falls short and prohibits too much speech. The short order also elides the complexity of this issue and fails to justify itself, and so therefore should be reversed. They say that if you are going to be impinging upon the First Amendment, you have to do it with strict scrutiny. They say the party seeking the restrictive order has the heavy burden of demonstrating that without this restraint, that a fair trial will be denied. That heavy evidentiary burden must be met, but here they haven't met it. In other cases, we've seen how this works, and the Sixth Circuit, too, has also employed a clear and present danger test. Sixth Circuit recognizes the separation of power and other things, but here, the order from Chutkan was imposed after the case against Trump had been pending for already 3 months. The government, Jack Smith, they introduced no evidence that any group protected by this order had actually ever experienced any threats. But the court found the government introduced, quote, undisputed testimony that when the defendant publicly attacks individuals, the individuals are threatened and harassed. And they say, okay, fair enough. But the court's abbreviated analysis did not connect Trump to the attacks. Trump might say something about somebody, and somebody else might threaten or harass that person, but not Trump. Unlike criminal defendants, in a standard case, there is a significant national attention and analysis that followed Trump's statements. And to justify a prior restraint, the court must more thoroughly explain why Trump is causing the harassment here. There is no degree of certainty that Trump's prior restraint will work, and without any evidence, the government's order must fail strict scrutiny. And similarly, a prior restraint against, quote, any reasonably foreseeable witness or the substance of their testimony, it just goes too far. At least one potential witness is now campaigning for the Republican nomination against Trump. Other potential witnesses are speaking about President Trump's candidacy. And multiple candidates campaigning against him have invoked criminal charges against Trump. But under the district court's prior restraint, Trump cannot respond to him. That cannot be the narrowest, most narrowly tailored mechanism. They tell us more about the Sixth Circuit, and they say that this order is just too vague to satisfy the strict scrutiny standards. They explain, beyond the slipperiness of the target, the order is also having problems with his objects. It prohibits Trump from targeting potential witnesses, even a potential caucus opponent, by identifying him or calling for his voters to vote against him. But it's unclear who the universe is. Who are all these reasonably foreseeable witnesses? We can't tell. Now, the order's vagueness here restricts speech by inevitably leading Trump to steer far wider than he otherwise would, right? Trump just says nothing because you don't know. He doesn't want to get in trouble. What the order prohibits is so vague that it shades itself in contradiction. It simultaneously forbids Trump, for example, from making statements that target potential witnesses like Vice President Pence, and then explicitly says that Trump may criticize other people like Vice President Pence. So Trump must carefully parse every word and every mention when talking about Pence, but only the federal government and Pence know what his potential testimony is going to be, if he even is a witness. And so Trump has to be tap dancing around a minefield in order to figure out what he is allowed to say and not say. They say, for another example, the order also allows President Trump to criticize the government generally, including the DOJ. But how is that any different than targeting Jack Smith or the special counsel? And so fear of failure to comply with the order while also speaking on matters of political importance during a campaign is an almost axiomatic example of a court that can chill speech. The order's subjects cannot know what is fair criticism and what crosses into contempt. Is the line drawn at President Trump identifying members of the government generally by name or position? Is he prohibited from making statements about the weaknesses of the case against him because that targets special counsel or their testimony? Can he talk about how the accusations, without specifying the source, are wrong or fail to tell the whole story? Or can he comment on the testimony or a witness? Requiring someone to ask those questions and answer those questions whether the person's speech is chilled or not. Now, the order effectively prohibits Trump from discussing major campaign issues nearly 2 weeks before the Iowa caucuses, with Super Tuesday just 6 weeks after that, when this trial is going to start on that Monday. The citizens of our states have a right to hear from the candidates on important issues, including when one of those issues is an ongoing prosecution against that candidate. Now, many officials, they say, engage in a rough and tumble of politics. Already, there have been circumstances where overzealous federal government action has led to the stifling of state elected officials and their voices. The risk that follows upholding the order of future prior restraints issued against political candidates in other contexts is deeply unsettling. Political opponents and opportunistic litigators may seek to stymie debate by relying on the precedent set here, and this would be an unwelcome burden on the democratic process. They say elections, including primaries, are a prime opportunity for elected officials to hear from their constituents. The Fifth Circuit explained this as well. They said restricting official speech is crucial for the listening citizens. And a presidential election is a key component of our democratic republic. A prior restraint on any major party candidate in a primary, much less a general election candidate, stands just as likely to inhibit communication between constituents and officials. And Trump being restrained from discussing matters of importance with his potential constituents, that's us, and the states are being prohibited from learning about those conversations, are problematic as well. So given the magnitude and importance and effect of such overly broad and vague prior restraints on Trump's speech, this court should reverse. Respectfully submitted by the Attorney General of Iowa, Brenna Bird and Eric Wesson, and signed by a bunch of other state AGs. We've also got West Virginia, Alabama, Idaho's here, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Utah, Texas, South Dakota, Carolina, Oklahoma, North Dakota, and Nebraska, all here signing off on this one. And so it looks like we've got a bunch of AGs all signing off on this, and we'll see if any others join. But they are right. We have a right to hear from Trump and to hear what he has to say about all this stuff. Of course, he is in the middle of it. He's in the thick of it. He is the person who's being prosecuted by his political opponents. But some people do not want to hear from Trump. In fact, this is Kinzinger and this is Christie we'll hear from before we get to Marjorie, who are saying that Trump is the greatest threat. He needs to be stopped no matter what. His First Amendment rights be damned. We have to stop him because he is dangerous to the future of the world.
What do you assess the third party movement, if there is another candidate, knowing that these presidential elections are made state by state? What's your analysis?
I'm worried because, look, I love the idea of a third party. I love the idea of a centrist party. It has to start in the House of Representatives before it goes to the president. Now, here's the deal. I think Donald Trump's base of support is very firm. I don't think you're going to peel anybody off of Donald Trump into something else, right? There are people like me, that not me, but like me, that don't agree with everything Joe Biden does, but would vote for him as opposed to Trump. If you give them an out, you give them a Joe Manchin or somebody, they'll vote for that person. And you may be like, and I would say this too, like, good, vote your conscience. But the problem is the consequences of a Donald Trump victory are so dire that I think you have to hold your nose and vote for somebody maybe you don't like, because we can survive 4 more years of Joe Biden. I'm not sure we can survive 4 years of Donald Trump.
Oh, man. So they're getting very nervous, and that is not a good position to be in. Like, you do not want your message to get out the vote to be just go hold your nose for our guy, right? Not really what you want there. Now, this is Chris Christie, and Chris Christie really needs Donald Trump to be convicted and removed, probably imprisoned if he's going to have any shot at winning. But that's their whole strategy now, right? Indict, convict, and remove.
The fact is, here's the problem, Sandra. This is all a play for second place if you don't go after Donald Trump.
Yeah.
And Nikki Haley said the other night, he's the right president for the right time. Well, I don't know that somebody who got indicted 4 times based upon their conduct in office turns out to have been the right president for the right time. And, you know, I look at the way they cuddle up to Donald Trump. Well, good. If you're content with second place, then don't take on the front runner. I've been taking on the front runner from the beginning because I want to win this race.
Totally disqualifying to say that any of Trump's indictments are legitimate reasons why he shouldn't be president, because they are illegitimate indictments, right? They're not actually anything that is based in reality or justice. It's all political, partisan nonsense. Chris Christie knows that, but he's just using this as a tool to victory, okay? He's actually using his enemies, to so-called, to take out his top opponent so that he can move into the top position. It's pretty reprehensible, but that's who we're talking about. Now, here's Marjorie Taylor Greene to close out this segment, explaining we'll be voting for Trump from jail, baby.
And if he gets convicted of one of the myriad criminal offences he's been charged with, and if, I'm not saying when, if he is convicted and he gets a jail sentence, will he be president from a prison cell?
Absolutely. People are going to vote for him even if he is in jail. I would vote for him even if he's in jail because we have communism in our country.
That's right, Piers. We're voting for him no matter what. You guys can indict him 34 more times. Nobody cares, okay? Because it is illegitimate. Nobody believes in your Justice Department anymore. And that's by your own doing. It's not anything Trump did. It's by you guys deciding to break 234 years of historical precedent, prosecute your political opponents 4 times, change laws in New York to create new civil actions with Miss Bergdorf, try to take away $250 million of his businesses, and so on. People are starting to get irritated about it. 18 state AGs are now jumping in on it. There will be more, no doubt, and we'll be here to continue to cover it, my friends. Thank you for joining us as we do. Don't forget to check out robertgovea.com if you want to access any of the mind map we just went through, or go download the PDFs that we just reviewed. It's all available at robertgovea.com. You can also sign up for the daily newsletter there so that these segments will be delivered to your inbox. That way you don't miss anything, and we'll be looking forward to seeing you right back here on the next one. All right, my friends. Well, that is it for us on this lovely, early, beautiful morning Friday. I hope your week is incredible. Let's see what you have to say about this. Of course, we talked about Engoron's illegal gag order. I think next week we've got some pretty interesting stuff queued up. Let's see. Do I have anything on the calendar for us next week? Yes, we got a motion to dismiss reply deadline due. We might get a Colorado ruling. There were closing arguments earlier this week that were extremely boring, but we're going to go through the ruling when that ruling comes out, if it's a bad ruling, I'd suppose. And so next week should be pretty busy. We'll be back here, of course, on Monday to get into it, of course, but we're not done yet. Let's see what you guys say about this. Of course, we got some amazing friends over on the tubes who are supporting us on the day. And we got Zach Nichols is clipping for us. Thank you, Zach. In the house, clipping away for us. Zach, you're the man. All right. So let's see who we got here today. Catherine Rex is starting us off this lovely morning. Says, hi, Rob and mods. Happy Friday. Every Friday, I feel like a magician. I make money appear and immediately make it disappear. Poof. Call me crazy, but I do not think Bidenomics is working. From Catherine Rex in the house. It comes in, it goes right back out. There was that funny, I think there was a funny video on X going around where some ladies at the grocery store, and every time they open a new thing, she cringes, right? It's like a new, pack of whatever. Oh, no, oh. And the price just keeps going up. Spud says, Rob, you should start your own company. Field of Meatballs. Sounds delicious, man. Could you imagine just frolicking through a dewy field of meatballs? It'd be heavenly. Sounds like a better company for my mama. I'll pass that one along. Jarbot is here. Says, Rob's going to a secret society meeting in a ghost town. What can go wrong? I think I've seen that movie. Yeah, I'm either, probably going to be eaten by mutants from the people who are living in the hills, or I might come back a mutant myself. I don't know. We'll have to see. Monday's show should be a lot of fun. All right, thank you, Jarbot. It's going to be fun. It's like a I don't know what you'd call this group, but it's a personal development type of thing. It's an experience type of thing. So it's going to be fun. Good to see you, Jarb. Should be a good time. Catherine Rex is bringing in some membos, bringing in the real Kittler's coming in here. Good to see you, Catherine Rex. Thank you for bringing in the real Kittler in the house. We got Brad Bowers says, I honestly think Trump gets off on everything. That's pretty optimistic take there, Brad. I think, I think that there's, I think Fannie's case is very weak. I think she overshot on that. I think I don't even think that one goes before the election. I think the Docs case is also weak. The only one I'm really concerned about is the J6 case. Genuinely. Because that is such a rigged jurisdiction. It's just hard to even, it's hard to win there no matter what. But I like it. I like the optimism. We got this from Knox Bierman. Says LARP, good term. I did some digging on her. She is so wannabe. I am embarrassed for her. She's pretty bad. She's really, really excited to be a judge, and she's not really a judge. And it's like, hey, come on. Somebody just needs to sit her down and be like, look, you're not a judge. Okay, just relax. Find something else to do. We got this one from Jarbot is here. Says, do you think the appeal was the reason for Alina meeting with the judge rather than a settlement? Never seen so much gagging in court. What are the chances this will be permanently stayed? I think high, actually. I think high. I think what the judge has done is wild. Gag the attorneys from even making a request. Maybe the portions about I don't know. I think the whole thing should be thrown out personally, and I'm hopeful that the New York judges do it. I don't know much about New York, other this. We're in state court, New York. I know more about the Southern District of New York, which is a federal court, but we're in state court, and it'll be curious to see. But I would hope that it's permanent because it's unconstitutional. Hopefully they get it. We got Jackie Carrion. What's up, Jackie? A membo for 7 months. Woo! All right, Jackie, we're almost all the way to a baby. Says, thanks for all you do. Great work to you and the Watching the Watchers community. We do have an amazing community, and Jackie, wouldn't have it without you. So thanks for being a membo. Thanks for supporting us and for stopping by. We got Peng's here bringing in a new membo. What's up, Peng? Thanks for being a membo and bringing in a membo. Steve H is coming in courtesy of Peng1, and it's great to see you both. We got Glenn Croy, who's coming in. It says, who's bringing in some membos? Glenn Croy is bringing in Douglas D, Crypto Po Boy. We got Dave M, Dr. T, and Valhalla Awaits, all coming in courtesy of Glenn Croy in the house. Thank you, Glenn. We got 1917 Beamer. Says Greenfield is just training for Engoron's job. Is that what this is? It's she's she's in training. She's a trainee. You don't mind if she sits in here on this important trial, do you? No, I guess not. We mind. Yeah, we mind. Good to see you, Beamer. Voice of the People, bringing in 10 new membos. Wow, Voice, thank you for doing this one. We got, who's coming in? Voice of the People brought in Rebellious Unknown, Magic Stick. We got Laura. Holy F is here. David D, Alan B, Mr. No, Samantha R, Darren M, and Nikki P coming in thanks to Voice of the People, bringing in some new membos in the house. Thank you, Voice. What else? We got Mars is here. Says contumacious is now by Bidenomic standards a $10 word, but still only worth $3. Heyo! That's a good one. Contumacious. That's a $3 word. Back in 2020, it was a $3 word. Now it's a $10 word. I can't even afford it anymore. I'm just going to use stubborn, okay? Contumacious is too expensive for me. I can't afford it now. I'm going back to the word stubborn, thanks to Bidenomics. Jarbot says, since the prosecution on the gag orders all play off each other, do you think the D.C. court, Judge Chutkan, will see this and be more cautious in her bias? Have a safe adventure to the ghost town. Thank you, Jarbot. Yeah, hopefully it's beautiful and safe, and hopefully I don't come back possessed or anything. It should be fun. But the... So it's interesting because they're both at the appeal status right now. They're both being decided right now. And in other words, Chutkan is probably not going to have much of a say in it. So the Court of Appeals will decide that, and I'm sure the Court of Appeals will think of many of the same issues that we thought about in New York. So I'm hopeful that both of them actually get remanded with some serious modifications as to why they're illegal, as to why Trump has free speech. And so I think that ultimately Chutkan's will also have some reversal happening there. And if not, it'll go to the Supreme Court, which I think is where the reversal will happen later on. We also have Catherine Rex in the House says, oh, come on, Rob, we can get through 2,000 pages. I was almost feeling it. You know, if I didn't have this ghost town trip, maybe we would have tried. What's up, Catherine? Thank you. We got Not Brandon says, just because Engoron likes gagging around doesn't mean he can force others to join in. We've got rights in this country, from Not Brandon. We got Glenn Croy says, 5 membos, more coming in. Napoleon is here. Genius by birth. Pickle jars. We got Sheep Herd, and Mother of P is coming in. All thanks to Glenn Croy in the house. Thank you, Glenn, for bringing in the new membos. And hey, YouTube membos, don't forget to grab the Telegram link. You can navigate over to the community tab section on the YouTube page, scroll all the way down, grab the Telegram link, and you'll join us there for the membos only after party, which is where we'll be going very shortly. We got Knox Bierman says, oh, so now we know where Counselor Abba has been. Thesaurus land. Yeah, there were some good words in there. Were those Abba's words? Man, she's so smart. Thank you, Knox. Wendy says, love that they submitted a 2,000-page petition. So while Haba wasn't in court, she was busy sticking it to him. Love it. Totally. Yeah, a big whopper. And they're like, hey, if you doubt what we say, here are the transcripts. Just go read it. It's right here. It's like, and hey, if they're going to deliver us 13 million pages of documents, least you can do is read 2,000 of them. Okay, just think about that, by the way. Did you see how big that document was? I couldn't even scroll through it. Now multiply that by a factor of 100,000 or whatever. Wild. All right. Good to see you, Wendy. And thanks for the no-no. We got this one coming in from Doogie Fresh. Doogie Fresh says, which motion in D.C. can actually be appealed to Supreme Court and stay proceedings and move the D.C. trial date? Venue, bias, immunity, select. Well, I don't think any of them, unless there's some reason to move it. The closest thing I think might be a discovery problem or like a SEPA problem. But yeah, the judge is just going to deny all of those. Deny, 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 deny. So if Trump, I think discovery is probably the best justification for an extension. Like if Trump literally does not have access to something like SEPA or did not have the proper time to review something before the trial date, then they will maybe have a shot. But I think the judge is going to hold the schedule such that they don't. Is going to really anchor them in. Nope, your deadlines are here. You missed it. Don't have it, whatever. Settle it, then. She wants this to go. Like they want this trial to go on this date. So I don't think that there's really much there other than SEPA or some discovery stuff. Let's see. We got, so Jigam, I'm going to save that one for the after party. Wendy K is here, says, what the heck? This judge is deranged. Deranged. Well, just like the DOJ over there. Quarter Native is here, says 6 a.m. Really, Robert? Are you kidding? So we got must be a California over there. Says, did you see Michael Rappaport got red-pilled? The ultimate TDS sufferer, so not on my bingo card. I did see that. I really have a hard time listening to that guy, so I didn't listen to it, but I just scrolled past it. I was like, oh gosh. But I did read the headline. And yeah, that's interesting. He's probably not alone on that. Spuds is here, says Christie, coming from the same guy who not only indicted a ham sandwich, but ate way too many of them as well. That's from Spuds. Good to see you, Spuds. This one is from Wendy K. Says, this was just posted about the Georgia 2020 and voting machines. And we'll look at that in the after party. We got Knox Bierman says, Rob, thank you for this super heavy dock lifting. Tell us about your trip when you return. I will, no doubt about it. Yeah, it's going to be a good time. Today's just a day trip. We're just going up and back. And then tomorrow will be the kind of the seminar workshop event. So it'll be fun. But yeah, we did a lot of docs this week, man. A lot of docs that we were reading through. And so thank you, Knox, for that. 51K, we'll read that in the after party. T. Lewis was down here. Let's see, T. Lewis shared this one. So T. Lewis is laughing. What's up, T. Lewis? Thank you for that. We got MD Coiner, who's also here. MD Coiner says, one membo is coming in from Old Chief. One membo from Old Chief. Good to see you. Thank you, MT Coiner, for bringing in the new membo. And Mahiri King is here. Mahiri King is here. Been a supporter for 5 months, man. We're almost over halfway to a baby. His villain name is Angrymon instead of like Engoron. It's Angrymon or Areolamon, something like that. I like it. Mahiri King. Very, very nice to see you, Mahiri King. And of course, thank you, Zach, for clipping all of those for us, my friends. We're going to jump over to X and see who is joining us over there before we wrap it up and go to our members only after party at watchingthewatchers.locals.com. We got a couple comments certainly to get to over there. But let's see what's happening on X. We got 7 viewers. It's a little early, but we got 7 viewers over there, which is perfectly okay. What's up, Mitch? Hey, Feline is here. Says, my prayer is that the good and wise will rise up. The fact that 18 AGs are willing to fight for not just Trump's right to free speech, but indirectly ours as well. Unjust gag orders cannot go unchallenged. Otherwise, we risk it becoming the standard and free speech being eroded for everyone. We got Danny McWilliams is over there. Good to see you, Danny. And those are some of our friends on the X platform. Of course, you can follow us over there at Rob Govea ESQ. You can also check out our community called the Watching the Watchers community, which is growing every day. Search for us over on the X platform, and you can see us there. But my friends, that is it for us on the day. Of course, before we wrap it up, want to remind you about our website, robertgovea.com. Remind you about fieldofgreens.com, where you can save 30% off. It's Black Friday super sale. So VIP is the code to use. VIP is the code to use, fieldofgreens.com. Watchingthewatchers.locals.com is where we are headed now. Before we wrap it up, certainly want to say shout out to our meme smiths and our mods who mod down the fort for us and keep things nice and orderly around here. We got Vienticus Prime, K-Bean, Just Cause, Playing Hooky, our friend Ronnie Cole, Zulu, Beyond Geo, Zach Nichols, John Allen, Janek 909, Dog Digger, and Donut Mind Me, and Zach clipping away for us today. Thank you, Zach. Shout out to our meme smiths, Geegum Geegum, Sleepy Dog Lee, and our friend Nathan, N810. Locals friends, stick around. We're going to be coming back to the after party. You don't have to move a muscle. We'll see you right back there in just a minute. But my friends, that is going to be it for us on the day, on the week. It's an early Friday show, and so I hope you have the rest of your Friday closeout in an amazing fashion. Of course, we are going to be back here next week to get into it all again. Of course, I remind you to unplug from politics. I remind myself mostly to do that. Try to get outside, try to spend some time with friends and family, get some vitamin D, change things up a little bit, because we've got to recharge our batteries. You know, we're just getting warmed up on a lot of these trials and a lot of these cases. And so we've got to keep our stamina and our fortitude nice and even keeled. It just means we can, take a break from time to time. And that's what we'll be doing this week. I hope you do the same and rejuvenate, because we're going to be back here next week on Monday to get into it all again. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends, an incredible Friday, and an amazing weekend. We'll see you right back here on Monday. Bye-bye.